Hello. Hello. Happy Friday. Good afternoon. Thank you for visiting my channel, Medical Assistant with Miss K. I am Miss K. If this is your first time visiting my channel, I am a medical assistant and medical assistant instructor. I've been in this field for 17 years now. And on this channel, I just share lessons and all things medical assistant, medical office assistant, and also CPR. So today I'm going to be talking about medical law, and I am doing this lecture from Medical Assistant Textbook, and it's by Walters Kluwer. And this is chapter 2 from that medical assistant book. So I'm going to go ahead and get started. I see there's a couple people watching. If at any point you have any questions or anything, just go ahead and put them in the comment section. But I'm going to go ahead and get started. Or maybe you're watching a replay. You can go ahead and post any questions in the comment section. And as always, if you have any questions or video suggestions, feel free to leave those below. And I'm also going to list my email below as well. So we're going to go ahead and get started talking about medicine and law. Hi, Deloria. I'm glad you could be here. I hope I said your name correctly. So glad you could be here, Deloria. As I'm going through, just let me know if you have any questions about anything. All right. So, introduction first. I'm just going to kind of read the statement right here about fraud and falsifying information. And then we're going to go ahead and go through the presentation. So it says Medicare fraud and falsifying medical records can result in a lawsuit, which is what we're going to be talking about today. Medical assistants and other healthcare workers are included in many of the suits brought to court. You may help to prevent many of these claims against your physician and protect yourself by complying with medical laws, keeping abreast of medical trends, and acting in an ethical manner by maintaining a high level of professionalism at all times. So this is what we're going to talk about today. And the definition of fraud is a deceitful act with the intention to conceal the truth. So this is what we're going to be talking about today. Now, let's just kind of look at the governmental and legislative regulations. Now, many of us, we learned this in elementary, middle school, right? The branches of government, which is the executive branch. You have the president, legislative is Congress and Senate, judicial is the court systems, right? And then we have federal government that comprises executive departments. We have the Department of Health and Human Services, Food and Drug Administration, the DEA, and the Department of Justice, okay? And then at the state government level, we have governors, state legislators, and court systems. And of course, each city has its own mayor. Okay, so this is just a little breakdown of how the government is set up, and then the executive departments, which we'll talk about later. All right, so understanding the legal system helps to protect you as the healthcare professional, right? Helps protect patients and also the physician or employer. Things that you must know are your legal duties. Now, one of the things I was recently talking to my students about is understanding your scope of practice. Your scope of practice is what you are legally able to do as a medical assistant or medical office assistant, right? And you have to stay within that scope of practice. Anything outside of what you are legally able to do means that you are going outside of your practice. A medical assistant who gives advice to a patient is acting outside of her scope of practice, and legally is considered to be acting without a license, and that is a criminal offense. So as medical assistants, if your patient, it could be something as simple as, your patient is in pain and they ask you what type of medication can they take, and you tell them, oh, go ahead and just take some Motrin or Tylenol. If the doctor has not instructed you to give those instructions to that patient, you are advising, and that means that you are acting without a license. So it's very important to understand your scope, okay, your scope of practice. Understand the legal nature of a physician and patient relationship, and also know the roles and responsibilities as a physician's agent. Now, litigation, that's the process of filing or contesting the lawsuit. All right, so branches of law. The branches of law, we have public law, and then we have private or civil law. Now, public law, that is issues between the government and citizens, okay? For the 4 subgroups is criminal law, constitutional law, administrative law, and international law. And then private or civil law, that's between 2 citizens. So, example, I'm just going to use you, Deloria, as an example since you're watching live. But let's just say Deloria, I say, Deloria, can I borrow $1,000? And you say, sure, Miss K. and I tell you, okay, I'm going to pay you that money back, I promise. And then you start asking for your money, and I'm ducking you, and I'm not paying you your money back, and you take me to court. That is considered civil law, because it is between you and I, and it's usually not criminal in nature. And medical professionals are covered by private law. All right. So subcategories to medicine, we have contract law, which we'll talk about today. Commercial law, we won't. And then tort law, we'll also talk about today. So tort law includes injuries inflicted by the wrongdoing of others, misdeeds resulting from the breach of a legal duty. And then it is the basis of most medical litigation. Now, a breach, many of you have heard of, I'm sure, breach of contract. That's when the terms are violated. So that means that, like the example I just used, the lawyer, I didn't give you your money back like I said I would. I breached our oral contract. Okay. And then tort is the righting of wrongs or injuries suffered by someone because of another person's wrongdoing. And that's whether it's intentional or unintentional, which we'll talk about in just a little bit. So the rise in medical malpractice cases are due to a few things. So scientific advances, it's an increased risk and potential for complications. So, one of the things I was recently talking to my students about is how the medical field has advanced. We've come so far. And one of the downsides to that is trial and error, right? Because some of these new advances, they got to test it out, and there are going to be some there's some risk involved with that, right? So that is one of the reasons why there's a rise in medical malpractice cases. Also, unrealistic expectations. The patient blames the physician, and there are some patients who, they look at their physician almost as, as if they can do no wrong. And as patients, we want to, of course, rely on our physicians, and we put our trust in them, and we believe that they know what they're doing. We literally put our lives in their hands. But sometimes as patients, we can have unrealistic expectations. Economic factors. Some patients use lawsuits to get money. Some of us probably know somebody who will sue at the drop of a hat, right? And then poor communication. There's no bond with the physician. So those are just some of the reasons why there's been a rise in medical malpractice cases. Now, malpractice, that is a tort in which the patient is harmed by the actions of a healthcare provider. All right, so let's talk about some rights and responsibilities of the physicians, and then we'll talk about some rights and responsibilities of the patients. So they both have rights and responsibilities, right? When a physician begins to see a patient, they enter into a contractual relationship, right? And we're going to talk about the different types of contracts in just a minute, but they enter into an implied contract, meaning that based on their actions, they are in contract, right? And the physician's rights within that contract, they're able to limit to certain specialties or certain locations, right? They have that right. They can refuse to service new or existing patients with new problems unless they're on emergency room call. For an example, if a doctor has been seeing a patient for, let's just say, the doctor has maybe been seeing the patient for one problem, maybe high blood pressure, right? And then the patient ends up with a new condition. That doctor has the right to say, I can't treat you for that condition. So they have the right to refuse that service. And they also have the right to change their policies or their availability as long as they give patients reasonable notice of change. They must give notice of change when they're changing any of their policies, and also their availability, meaning they're changing their schedule. They used to be available Monday through Friday from 8 to 4, and now they're limiting their practice to only 3 days a week, right? And so, or maybe they were open on the weekends at one point, and now they have limited to just Monday through Friday. They have to give notice of that change. Now, the patient's rights. Now, the patient's Bill of Rights has 3 goals. Now, the patient's Bill of Rights, you all can find it online by just Googling the patient's Bill of Rights. But the 3 goals of the patient's Bill of Rights are to help patients feel more confident in the U.S. healthcare system, to stress the importance of a strong relationship between patients and their healthcare providers, and also to stress the key roles that patients play in staying healthy, by laying out rights and responsibilities for all patients and healthcare providers. And some of those rights are included here. Some of those rights includes the ability to choose their physician. So patients have that right. They have the right, they have the right to determine whether to begin medical treatment. They have the right to know in advance all the aspects of their treatment. And they have a right to privacy, and they also have the right to say no. So there's just some of the rights that the patient has within the Bill of Rights. And if you're in school for medical assistant, you probably were already provided this document if you've already got to that module. But if not, you can always, like I said, look it up online, the patient's Bill of Rights. All right, so contracts. So I mentioned just a little while ago that we will be talking about contract law. So a contract can be oral or written, okay? They both can hold up in law, okay? So first of all, let's talk about what a contract is. And a contract is an agreement between two or more parties for a given act. 1 second. Let me I don't know if you all can hear my phone vibrating. But it's going off today. Let's see. When I'm not doing anything, nobody is calling or texting me, but when I'm busy, okay, let's see. Let me put that. Okay. I just turned my I just turned it off. Okay. All right. So there's three components to a contract. You have the offer, which is the initiation. One party initiates the contract with an offer, right? And then the other party accepts it. And so that's the acceptance. And then the consideration, that's the fees for service. Okay. Now, I mentioned that when a doctor starts seeing a patient, they enter into contract, right? So the doctor's offer is having an open and available schedule, right? So that's the doctor's offer. That's one component. And then the acceptance is that patient accepting the offer by scheduling an appointment. And then once that patient shows up for their appointment and that doctor comes into that room and begins seeing that patient, a contract has formed. Children or mentally incompetent adults cannot legally enter into contracts. Okay. So a minor, a child can sign all they want to, but it will not hold up in court. It is not considered legal contract. And also mentally incompetent adults cannot legally enter into contract. All right. So implied contract. Okay. Think about what it means to imply something. When you imply something, that means that you are suggesting something, okay? So I usually, when I'm going over this lesson with my students, I spend a little time on this because, a lot of people tend to get these mixed up, okay? So just simply think of what it means to imply something. It means to suggest. So with implied contract, as I mentioned, the patient and physician relationship, that is an example of implied contract. Why? Because the patient is not signing a contract, is not signing a contract with the physician. The physician is not signing a contract with the patient, but based on their actions, they are entering into contract. So in a case with implied contract, that means that contract is assumed based on your actions, okay? And it is legal and it will hold up in court. The most common type is in medicine and it's not written. It's based on actions only. So Deloria or anybody, if you're still watching, just let me know you understand that. Just kind of let me know in the comments if you got that. I just want to make sure you understand that. And then express contract is the opposite. With express contract, you are actually verbalizing, right? It's an oral contract or you are signing a contract. So that's like the contract that we enter with, with maybe a loan, maybe a personal loan or auto loan. We're signing that we understand the what is the word I'm looking for? We are writing that we agree to this contract, to abide by the contract, right, and uphold our end of the agreement. It contains specific details and is not used as often in medicine. And also the example that I mentioned earlier with me maybe borrow money from Deloria, that is express contract because I verbally agreed to give her money back, and that would hold up in court. Okay. So I just want to make sure you all understand it. Okay, perfect. Perfect. Sylvia, thank you for watching, Sylvia. I'm not exactly sure I see your comment, but I'm not exactly sure what you meant by that. Okay, I'm glad you understand, Deloria. Okay, so implied again is assumed, express is actually stated orally or is written. Okay. Now, termination or withdrawal of the contract. So, a contract is ideally resolved with satisfaction completion, meaning that what you all entered into contract for was completed. Now, the patient can end the contract at any time. The patient does not need to officially withdraw from the contract. The patient has that right to just stop showing up. However, the physician, he or she has some steps that they have to follow. Okay. Now, there's three ways to end the contract. Patient initiated. Like I said, the patient can at any moment, walk away and decide they don't want to see the doctor anymore. Physician initiated means that the physician has decided to end the contract, and we'll talk in a second about how the physician has to end the contract so that he or she is not sued for abandonment. Okay. Now, patient initiated termination, they may they may verbally say, I'm not coming back. They may write a letter, but in my experience, if a patient doesn't want to come back, they may say something or they may not. But I've never seen a patient give written, not saying it's never done, but like I said, they don't have that requirement. All right. And so the physician, they can accept it. They'll make the records available to the patient, referrals available if needed. And if the request is made verbally, the physician should send a letter, document, and conversation, at least documenting it in the patient's chart. All right. So physician initiated termination. Remember, I said once that physician walks into that room and begins seeing that patient, a contract has formed. That physician and patient are now in contract. And the physician cannot just all of a sudden decide that they do not want to see that patient anymore. Now, there's a difference if the patient is a problem patient, right? Which we've had over the years. I've had experiences with patients where, we had to let them go because they were problem patients for whatever reason. But if the physician just decides they don't want to see the patient anymore, they have to go through these steps. So, first of all, they have to write this letter. We're gonna talk about it in a minute what the letter has to include, but it has to be sent by certified mail. Now, that is an exam question. So, for those of you that's going to be taking the CMAA, the Certified Medical Administrative Assistant exam, or even a CCMA. Maybe this is on a clinical medical assistant exam as well. I'm not sure, but it's definitely on administrative exam where they'll say a doctor wants to dismiss a patient. What type of mail does a letter need to be sent? You need to know that it's a certified mail, okay? And then when you get that return receipt, you'll just put a copy of it in the patient's chart. So what must be included in the letter? The physician has to have in the letter their statement of intent to terminate the relationship, okay? The reason, the termination date, which it needs to be at least 30 days prior, at least 30 days from the date of the letter's receipt. Statement that the medical records will be transferred at the patient's request, and a strong recommendation that patients seek additional medical care as warranted. So these 5 things must be included in the physician's termination letter or dismissal letter to the patient, and it has to be sent, again, certified mail. If the physician does not do these things, they can be sued for abandonment. A doctor can be sued for abandonment in the following cases. So if a physician abruptly terminates a relationship without notification while the patient still needs care, they can be sued by abandonment. If the physician fails to see the patient as often as the condition warrants, they can be sued for abandonment. Or if the physician incorrectly advises patient that further treatment is not needed, they can be sued for abandonment. They must arrange adequate coverage in their absence. So if a physician is going to be absent for a certain amount of time, they have to arrange some type of coverage. All right, so abandonment, that's the withdrawal by a physician from a contractual relationship with the patient without proper notification while the patient still needs treatment. Loca tenens. So you'll notice a few Latin terms in this lesson. I should have probably mentioned that in the beginning, but that's fine. You'll see a few Latin terms, but locum tenens means that a substitute physician, and I may be saying tenens wrong, but that's a Latin term that means a substitute physician. All right, so consent. So we talked about contract. Now we're going to talk about consent. What does consent mean? Consent simply means permission, right? So we're going to talk about a couple different types of consent. So there's implied consent and there's informed or express. So just like with implied contract, okay, implied consent means that consent is assumed based on the patient's actions. Okay, so for those of you that's working in the medical field, let's just say you are on the clinical side, let's just say you are, you're a phlebotomist or you're a medical assistant and you draw blood. And you are going to draw your patient's blood and he or she gives you their arm. That is an example of implied consent because they are giving you their arm. They're giving you permission based on their actions. They may not verbally say anything and they're not signing anything, but their actions are giving you permission, right? So that's implied consent based on actions, okay? Just like with contract, it's not expressed. With informed or express consent is they are verbally or they're verbally giving consent or giving written consent. Informed consent means that the patient is actually signing. They're signing the consent and they are agreeing that they understand the procedure, they understand the risk, the benefits, and that everything was explained to them. They're signing that they understand that there are other alternatives they consider, and that they're also signing that they don't necessarily have to have the procedure. Okay, and this is the actual definitions of both. So informal agreement based on actions. Oh, another type of informed consent is in life-threatening emergencies. So if you happen to have to give CPR to an unresponsive patient, like a patient has gone in a cardiac arrest, and you have to give CPR based on their unresponsiveness, you can assume that based on their unresponsiveness that they would want your help. Okay, so that is considered implied consent. Now, if you had a patient or a victim who was choking and they're alive, you have to get their consent. They have to nod their head. You have to ask them. If you've taken a CPR class before, when they ask, can I help you? I know CPR, I know first aid, can I help you? They have to nod yes, that you can help them. But when they are unresponsive, you already have their permission because it is considered implied consent. Okay, so I hope that made sense. Again, informed consent is actually signing a form given permission. Okay, they are given permission. They're signing to give permission. Okay, now these are some of the components of informed consent or express consent. They are signing that they understand the risk, they understand the benefits and the anticipated result of the procedure. They understand that there are alternatives. And yes, this is a test question. These are exam questions. Okay. All right, and this is just an example of using an interpreter. So there will be times where you as a medical assistant or medical office assistant may need to use an interpreter. So if a patient speaks a different language, depending on where you work, they may have in-house interpreters that can be scheduled, or some patients, they actually show up with an interpreter. And then some healthcare offices actually have access to a phone system where they can get interpreters on the line. And in this case, you see it looks like she's doing sign language. And so you may have a patient who is deaf, and the interpreter will show up to assist. All right. The patient should never be asked to sign an informed consent if they don't understand the procedure, if they have unanswered questions, or if they are unable to read the consent. And just to let you know, if the patient ever has questions or they don't understand, you have to direct them back to the doctor. Because again, remember I mentioned earlier, we cannot advise a patient. We cannot, give advice. So if the patient has questions, we have to let them know, wait 1 second, let me go back and get the provider for you, okay? Unless the provider specifically gives you instructions to give to that patient. All right, so who can sign a consent form? Who may sign a consent form? mentally capable adult over 18. Remember, I mentioned earlier that an incompetent adult cannot sign a consent form or a contract. It will not be legal. A minor under certain circumstances, if they're in the armed services, requesting treatment for STDs, pregnancy, requesting information about birth control, abortion, or drug, alcohol, or abuse counseling. And if they're emancipated minor. Now, an emancipated minor, that is a minor under the age of majority, but who is legally considered to be an adult. Who also may sign the legal guardian or healthcare surrogate. Now, notice it didn't say parent. Okay. Now, um, another test question. Every time I come across something that I know you'll see on the certification, I'm just going to kind of, put that out there for you. But if you see this question on the test, they may ask who can sign for a minor. It'll say legal guardian, parent, and some other options. It's going to always be the legal guardian because the legal guardian may not necessarily be a parent. Okay, so just remember that it's the legal guardian, not necessarily a parent. All right, so releasing medical information. If a patient's medical information needs to be released, there are some steps that we have to follow because that patient information is private, so they have to actually sign and give permission to release that information. Now, the medical record is considered a legal document um, if a if there's a medical malpractice lawsuit, they may subpoena the entire chart to be brought to the courtroom. Okay. Patients have a right to their medical information. It does belong to them, their information, even though the physical chart belongs to the doctor. The patient's information does belong to them. Okay, and they have the right to deny the sharing of that information, and they have the right to share that information, except in the case of legally required disclosures. What are legally required disclosures? Now, legally required disclosures, these are things that we have to report, and we don't need patients' permission for. Okay, like vital statistics, birth certificates, stillborn reports, death certificates, things like that. We don't need permission from the patients. We have to report this information. Okay. Other legally required disclosures are medical examiners reports for when they're looking for the cause of death, right? Infectious or communicable diseases. Um, Also, national childhood vaccine injuries. So any vaccine injuries that occur have to be reported. Abuse, neglect, or maltreatment have to be reported. These are all things that we legally have to disclose, that we legally can disclose without patient's permission. Now, if a provider suspects that a child is being abused, neglected, or treated badly, they're mandated to report that to a national hotline. Okay, if spouse abuse is suspected, um, it should be documented. It's not, they don't have to, they're not mandated to report spousal abuse, but they should document it in a chart. And if you ever suspect that maybe abuse is going on, you can let the physician know. Okay, just let the physician know, because you're going to be the one who sees and talks to the patient first before they get to the physician. So you may say, hey, I'm just using this name and this as an example. Hey, Dr. Smith, I'm just letting you know that, Murray Doe in room 5. I think she may be abused. I think she may be getting abused. So let the physician know, so then they'll be on alert before they go in the room and start seeing the patient. I'm sorry for my sniffling. I'm starting to get a little cold here. All right. Also, violent injuries are to be reported, and also other reports like cancer, PKU results, and in some states, epilepsy and infantile hypothyroidism. Okay, so those are just some examples of things that can be reported because they are legally required disclosures, meaning we legally are required to disclose that information. Now, I mentioned tort earlier, which is a wrongful act that results in harm for which monetary restitution is sought by the injured party. So it's the righting of wrongs caused by another person, whether it's intentional or unintentional. Like many malpractice lawsuits are not always because of a physician intentionally doing something wrong. Sometimes it's unintentional. Sometimes the doctor makes a mistake. However, because it harmed the patient, they still are liable, whether it was intentional or unintentional. So the plaintiff, that is the party who initiates the lawsuit, and the defendant is the party that is accused. That is the person that is being brought to court. Okay. Negligence and malpractice. These are the majority of lawsuits. Okay. Negligence and malpractice. Negligence is a major component. Malpractice occurs when a patient is harmed by the professional's actions. And there are three types of negligence. Okay. Malfeasance, misfeasance, and nonfeasance. Malfeasance is, and these are again exam questions. This is information you may see on the exam, but malfeasance is intentionally committing an unlawful act. So that means that the doctor, the physician, the provider, they are intentionally doing something wrong. And think of mal. Think of the prefix mal, which means bad. That means that they are intentionally committing an unlawful act. Okay. Now, misfeasance is doing something that is, they're doing what they're supposed to do, but then they may make a mistake, right? So think of mistake. When you're trying to remember the difference between these two, mal is bad, and when you think of think of mistake, right? So misfeasance is, I've heard of cases where a patient was supposed to have a limb removed. Let's just say they were supposed to have their left leg removed. The doctor goes in and removes their right leg, right? It was a mistake, but guess what? The patient still has to have the correct leg removed for whatever reason. So now this patient has no legs. So it was a mistake. The doctor may not have intentionally went in and removed the wrong leg, but guess what? It happened. So that doctor is liable. So that is an example of an unintentional tort, right? It still resulted in the patient's harm. So that means that they made a mistake. Non-feasance means it was a failure to perform. So that means that the provider did not do what they were supposed to do. Like, so think of none when you think of that. None, right? So those are the three types of malpractice. All right. Registered nurses are not held to the same standards of physicians. Medical assistants are not held to the same standard as nurses. And then representing attorneys often seek expert witness to state standards of care. So the standard of care is, what would a reasonable healthcare professional do in that same field, in that same profession, same position, same specialty. That's how the state standards of care are set. And so it mentions here that nurses are not held to the same standard as physicians, and we're not held to the same standards of nurses because we have different, scopes of practice, right? We cannot be held to the same standard. All right, so to prove negligence, all right, so we talked just a couple slides ago about negligence, right? If a patient is suing a doctor for negligence, there are 4 Ds that must be proven, okay? You have duty. They have to prove that the patient and physician have formed a contract, right? They have to prove that that physician had a duty to that they had a duty to see that patient, that they had a duty to, complete or that they had a physician to see that patient, right? Their election of duty, they have to prove that the physician did not meet the standard of care. They have to prove that the physician did not complete that duty, right? Direct cause is the act or omission was a direct cause of the damage. They have to prove that that doctor's actions or his omission of the action, meaning the action that he omitted or left out, was a direct cause of the damage. Then they have to prove the actual damage. They have to prove that a damage did occur. So these are the 4 things that have to be proven, okay? The burden of proof lies with the plaintiff, and the plaintiff is the patient who is bringing the doctor there, right? And these are just some of the jury awards. So nominal, the compensation is very small. Some of you all may have heard about that before. A nominal award. A nominal award is, it can almost sound insulting. I don't know if any of you have ever heard of a lawsuit in which the patient was awarded like $2 or something like that. It's very, very small. Actual or compensatory means that the award was given to, to try to compensate, right, for a lost limb, or compensate for an injury, compensate for mental suffering or loss of income. And then the punitive is the most costly. That's a punishment for wrongdoing. So intentional tort. So I mentioned unintentional. So sometimes that torts are unintentional, right? Now these are situations of intentional torts, all right? So we got assault and battery, duress, invasion of privacy, defamation of character, fraud, tort of outrage, and undue influence. So let's look at those. Assault and battery. So the assault is legally assault is the threaten or the is to threat or to attempt to touch somebody, right? That means that the person is threatening to touch or attempting to touch them, right? The battery is the actual physical touching, and it doesn't necessarily mean you're hitting them. If even a medical assistant walking into a room and simply trying to take a person's vital signs without getting their permission, or at least implied consent, meaning they're giving up their arm, right? That can be considered battery. It's the actual physical touching. The rest is being coerced into an act. Invasion of privacy is sharing patient information. With HIPAA, I haven't talked about on this channel with my students, and I was just talking about HIPAA that requires patient information to be kept confidential. Written permission must be obtained from the patient. I mentioned that earlier. They have to give permission to share information. Okay, so this is an example of an intentional tort where you are, sharing patient information. You can't even share a patient's name. And it doesn't matter. I don't care if you talking to your best friend and you want to tell your best friend about, oh, guess who came in the office today? That is invading their privacy. Like nobody should know who your patients are, and they definitely shouldn't know any information about them. Another intentional tort is defamation of character, making malicious or false statements. Libel are written statements. So let's just say somebody's on, Facebook or, spreading false information about a person, ruining their reputation, right? Or, tweeting about a person or writing a blog about a person. That's defamation of character. And then slander is verbal statements, okay? Going around spreading false information verbally. Fraud is intentionally raising false expectations regarding recovery, not properly instructing the patient regarding possible side effects of a procedure, and filing false insurance claims. Yes, there are providers out there who file false insurance claims to get money, to get more money. They may, upcode a person's CPT code and to get paid more, or maybe they may add a false diagnosis to justify a procedure they did on the patient or a test they ordered. It happens. A tort of outrage, another intentional tort intended to inflict emotional distress, acting in a manner that is not morally or ethically acceptable, causing severe emotional distress. An undue influence is improperly persuading another to act in a way contrary to that person's free will. So those are all examples of intentional torts. Now, the litigation process that begins when a patient consults an attorney. The attorney will obtain the medical record, and they will issue a subpoena. Now, a subpoena, you all, I'm pretty sure, have heard of a subpoena. That's a court order requiring an individual to show up in court. And then a subpoena ducis tecum, that is a subpoena for the medical record. So they may need the actual medical records. It's reviewed by a medical legal consultant, and the plaintiff's attorney files complaint, defendant attorney answer. Discovery phase begins with interrogatories and deposition, and then they filed a subpoena for medical records. And then you go through the trial. The bench trial is a trial in which the judge, I said George, trial in which the judge hears the case and renders a verdict, no jury present. And then appeal is the process by which a higher court reviews the decision of a lower court. So let's just say the lower court, they rule in favor of the physician, and they want to, and the plaintiff side wants to appeal it, or vice versa. They will go through that process to get the decision reviewed again. Now, defenses to professional liability suits. So medical records, that's the most important component of the defense. The medical record, as I mentioned earlier, is a legal document. So this is why it's so important to document everything. Document. One of the first rules of being in the medical field, you got to understand that if it's not documented, it ain't done. It didn't happen. You have to document everything. Any conversations you had with the patient, You want to document it. The patient doesn't show up for the appointment, document it. The physician had a conversation with the patient and told that patient the importance of taking that medication, and the patient didn't take it. Document this stuff. We had a patient when I was working in cardiology. We had a patient call in with chest pain. We instructed the patient to call 911 or have someone drive them to the hospital, and the patient decided to drive themselves and had a heart attack. And guess what? We documented that conversation in the patient's chart. So if that patient tried to sue, we had documentation that we told that patient, look, you need to call 911 or have someone take you. So documentation is so important, because if it's a case where the physician is really not in the wrong there and it really was the patient, that documentation is what's going to help that physician. Accurate, detailed medical records are crucial. Okay, it's crucial. That is a crucial duty of a medical assistant. Document, document, document. All right, so statute of limitations, um, um, that is a length of time that a lawsuit may be filed, right? So depending on where you live, where I live, the statute of limitations is 3 years. So if a patient tries to sue a doctor in my state for something they did 5 years ago, they won't be able to, because the statute of limitations, we are beyond the statute of limitations of 3 years. Assumption of risk. That means that the patient was aware of risk and knowingly accepted them. That is why signed consent forms are so important, because the patient is signing that they understand that there are risks, and they're signing that those risks were explained to them. All right, another Latin term, I told you all we'll see a few Latin terms. Res judicata, that means that the thing has been decided. Once the lawsuit is settled, the losing party may not countersue. Okay. Contributory negligence means that both the physician and the patient contributed. So, meaning that, yeah, the physician was responsible, but also maybe the patient wasn't taking their medications the way they were supposed to. Maybe they were missing appointments. So, in some way, they contributed to the damage. And the comparative negligence, that's the percentage of contribution to damage. That's when it's evaluated. Like, how much of the damage did the patient contribute to? How much of the damage did the physician contribute to? Okay. Another Latin term, respondeat superior. This is important to know whether you're on the clinical medical side or the administrative medical side. It means let the master answer. Now, what does this has to do? What does this have to do with the medical field? It means that the doctor is responsible for their employees, right? So, as a medical assistant or medical office assistant, as long as you are acting within your scope of practice, the physician's insurance covers you, right? Their malpractice insurance covers you. So, as I mentioned earlier, as a medical administrative or a clinical medical assistant, we cannot give medical advice. So, if you give medical advice to a patient and something happens to that patient, guess what? They can sue you, and the doctor is not liable for you, so they can sue you. However, let's say as because you are outside of your scope, so that medical so that the provider isn't liable for you. However, let's say that you were acting within your scope. Clinical medical assistant, you were given a vaccine, somehow you did something wrong and caused a patient harm. Because you were acting within your scope, you are covered by the doctor and they are liable for you. So just remember, that's why it's so important for you to always act within your scope of practice, okay? Whether you're on the administrative side or on the clinical side, okay? Make sure that your job description is in written form and that you understand it. Practice within the job guidelines. Always seek clarification. Ask the doctor, okay? And then malpractice insurance. Now, providers have that. This is, some people, they do walk around with their own insurance. It's not mandatory. It's optional, but it's an option. All right. So employment and safety laws, the Civil Rights Act of 1964, enforced by the Equal Opportunity Employment Commission. And also it states that employers may not refuse to hire based on race, color, sex, religion, national origin, and things like that. They cannot ask these types of questions in interviews. They are considered illegal to ask those type of questions, to ask personal questions. They can ask about convictions if you've ever been convicted before. They can require drug screening. So this is important to know. AAMA prohibits convicted felons from taking a CMA exam, the Certified Medical Assistant. And I believe also I believe the registered medical assistant exam as well, if I'm not mistaken. Now, this book that I'm teaching from, of course, is from 2016. So I don't know if things have changed since then. We are in 2022, but as of the publishing of this textbook, this was the case. Now, as far as the CCMA, I believe that that is fine because the student that we had at my old school that I was teaching, clinical medical assistant, we had a convicted felon and she was not able to take the RMA. However, she was able to take the CCMA, which is a certified clinical medical assistant through NHA. So, like I said, it's good to look into because this was back in 2016. So I don't know if anything has changed since then. Things are always changing in the medical field, so we never know. Also, sexual harassment, of course, is prohibited in the workplace. Americans with Disabilities Act that require, facilities to make, to make facilities more, what's the word I'm looking? Oh, accessible for handicapped people, entrance ramps, right? Braille signs for disabled, for blind patients. Also prohibits discrimination against persons with disabilities, right? Some of you probably notice in more and more places you're beginning to see people who have, visible disabilities, right? This is because they're required to give these people a chance in certain jobs that they are able to carry out. Um, and then this is just kind of going into more detail about how they're, prohibiting discrimination against people with disabilities. Also applies to AIDS or HIV positive because they are also a group of people who have been discriminated against, history of mental illness, and then those with cancer. The Genetic Information, the Non-Discrimination Act protects against employment. Believe it or not, some people are discriminated against because of their genetic information. Um, Prohibits health insurance plans from requiring genetic information in order to make decisions regarding health insurance coverage. Now, OSHA is the Occupational Safety and Health Administration. Now, they set the guidelines for keeping the workplace free of hazard, keeping the workplace safe. So they have specific rules that apply to bloodborne pathogens, and bloodborne pathogens are viruses that can be spread through contact of blood or bodily fluids from an infected person. Now, the number one rule, ladies and gentlemen, treat all patients as if they're infectious, right? Treat all bodily fluids, blood, everything as if it's infectious, right? You want to always have your gloves on when you're dealing with any blood or bodily fluid, right? Um, Always treat people as if they are infected. Okay, don't ever look at a person and assume that they don't have anything. Because I've been in this field for 17 years and I've seen so many different things and encountered so many different patients. To me, everybody has something to me. It's just ingrained in me because I've seen so many different things. But OSHA requires employers to make sure that they have things in place, right? To make sure that they have gloves and gowns and face masks, and that they have places for us to dispose of needles. Like we have to dispose of needles and glass in the sharps box, separate from regular trash. We have to dispose anything with bodily fluids on it in the biohazardous box, right? HIP, I was about to say HIP. I'm sorry. OSHA requires that, and they do come in and check from time to time. I've had situations, the school, that I work for, they come in, they check, they look in the trash, make sure there's no needles, make sure there's no bloody gauze, bloody band-aids, and things like that with regular trash. And OSHA, we'll talk more about that later. Um, Clinical Laboratory Improvement Amendments, CLIA. They contain specific rules and regulations regarding laboratory safety. The Joint Commission is a private organization that sets standard for healthcare administration. Now, unlike HIPAA and OSHA, the Joint Commission, or JCO as we call it, they are not mandatory. That is an optional organization So not everybody follows JCO standards. Each state has specific laws regarding patient care, insurance billing, collections, etc. Now, I wanted to do a separate video on ethics. I wanted to kind of focus on law today, so I'm not going to go into the ethics part of this. I'm going to stop right here. I just wanted to kind of focus on law, and I'll just do another follow-up video on how sometimes the relation of law and ethics, and how sometimes, ethics or your personal ethics may clash with the law. There may be some things that you don't agree with that are legal. So again, like I said, I'm going to go ahead and stop here. Thank you to you all that have hung in there for this lesson. I hope that this is helpful. I will save this to the channel so it'll be available. If you have any questions or video suggestions, always, as always, feel free to email me. My email is in the description box. If it's not there already, I will add it once I end this video. But again, thank you to those of you that are still watching right now, that are still tuned in. If you have any questions, let me know and I can answer to the best of my ability. If you're not already subscribed to this channel, consider doing that for me and also liking this video. Thank you all and have a great day.